Lawyers who've told a client, "Relax, we got this," but deep down you knew your client is getting cooked. Story 1. Our firm represented a mother who filed a case on behalf of her 2-year-old son. The parents were separated, and at the time, the child was staying with his paternal grandparents. While the boy was in their care, the grandmother went out to mow the lawn. Tragically, she didn't see him and ran over her own grandson with the lawnmower. He suffered deep lacerations to both legs, and one of his feet had to be amputated. The grandparents didn't have much money, and their home was their most significant asset. We offered a settlement. The house would be placed in a trust, they could continue living in it for the rest of their lives, and once they passed away, it would be sold to help cover their grandson's medical expenses. They refused. Their reasoning: they had other grandkids they wanted to inherit the house, completely ignoring the fact that they hadn't run over their other grandchildren with a lawnmower. They pushed the case to trial. Their defense was that the mother had been late in picking up her son and that awarding a large judgment would somehow damage their relationship with their grandson.
They lost.
The jury awarded the boy $2 million. Before we continue, do us a quick favor. Smash that like button and subscribe to support our channel. Story 2. I am an engineer, not a lawyer, but I was involved in a pretty interesting case. About 30 years ago, someone subdivided their parents' property to build a house. The township initially said the new lot was unbuildable because the entire subdivided area was within the floodplain. The homeowner hired an engineer who submitted calculations showing the house wasn't in the floodplain, and eventually they were granted the permit. Fast forward about 23 years. One night, the property flooded badly. It was so severe that the boat stored in their garage, which was directly below the bedroom, got lifted by the water and started banging into the ceiling, waking them up. Naturally, they tried to sue the township, claiming they should never have been allowed to build in the floodplain. But here's the kicker. On the very first page of the original permit plan, 30 years old, was a clearly written note that said, "I understand the township is under the belief that this property is in a floodplain. By signing this document, the applicant understands the township is in no way at fault for any and all damage which may occur during a flooding event." It was signed and dated by the guy now on the stand trying to sue the township. Story 3. This happened to a friend of mine a few years ago in Canada. In a case against Telus, Telus had offered him a promotion on his contract, but he always called in and insisted on keeping his original contract price, which was $15 cheaper than the current rate. Every year he would call and ask to extend his contract for another year at that original price. Last year, however, that price was practically unheard of. When he called in again, they immediately bumped up his rate, claiming he was on a glitched account and that his original contract was no longer valid because they said he hadn't signed a new contract each time it was extended. Then they charged him over $8,000 for the plan. What Telus, and specifically the rep and department involved, failed to do was check the contract he had. If they had, they would have seen that he did have documentation. He had emails, phone call logs, dates, letters, and even screenshots to prove it. So he took Telus to court. He hired a high-end lawyer and sued for damages, mental anguish, breach of contract, and pressure tactics. In British Columbia, the maximum allowed in small claims court is $40,000, and that's exactly what he sought and won. Before the hearing, his lawyer even warned Telus, "I've submitted a lot of evidence in discovery. Are you sure you want to go through with this? It's a strong case. I highly advise you to review it." Telus declined, saying they had all the proof they needed. Their proof: the original contract with an expiration date. Their defense looked confident and smug. His proof? Every amended contract email, names of agents, dates, phone call transcripts, many of which had come directly from Telus. The judge ruled in my friend's favor and even commented, "He gave you a chance." Story 4. There's a reason I always explain to people, employers and others, why I keep every single email I've ever sent or received, and why I refuse to just phone up somewhere to resolve something. I want it in writing. I want it in an email. The number of times I've dug back through my inbox, my personal record is about 10 years, and pulled out the winning card is unbelievable. At one workplace, I received some IT equipment, but they failed to deliver everything as specified. It turned into a serious dispute. I was fairly new on the job, and we were talking about a lot of money and a significant amount of missing equipment. The supplier insisted they had delivered exactly what was quoted and claimed we'd have to pay substantially more to get what we were asking for. It escalated to the point where I found myself, new employee, sitting in a meeting with my company's director of finance, also my direct boss on one side, and the CEO and finance officers of the supplier on the other. We were on the verge of legal action. They were threatening to take us to court for non-payment, and we were preparing to sue them for breach of contract. This meeting was essentially the final attempt to avoid handing it over to lawyers. The supplier brought reams of documents, emails, invoices, quotes, and made their case. Tensions were high. My director of finance was visibly frustrated with me for letting it escalate this far. After a long, tense exchange, all attention in the room shifted to me. I said, calmly, "We placed an order for this kit exactly as we specified, were quoted a specific price in pounds, agreed to that quote, and your company accepted the order, but then failed to deliver what was promised." The supplier almost laughed at me. "Can you prove that?" they asked. "Yes," I replied. "Here is the email chain in question, each message with full headers showing the time sent and received, who sent and received it, and the unique exchange ID generated by your own email servers. It clearly outlines the agreed specification, includes a quote detailing the price, my acceptance of that quote, and your agent's confirmation along with the expected delivery date." Somehow, despite everything escalating to this level, they had no record of that entire chain of emails, half a dozen messages sent by their own employee. All they had were the earlier quotes and specifications, which had since been corrected before any order was placed. But instead of delivering the updated, confirmed kit, they sent us the earlier version missing substantial, expensive, and essential components, and were now claiming we never ordered them. To make things worse, for them, the final price listed on the corrected quote and purchase order was slightly different from the earlier ones. It wasn't a copy and paste error. It was clearly a separate quote. And it was an incredibly competitive deal for the hardware involved. Otherwise, I wouldn't have gone with them. Someone on their end clearly made a mistake. And rather than own up to it, at which point we probably would just pay the difference, they doubled down. Their employee must have realized the error, deleted the email chain from their end, and tried to cover it up. And they almost got away with it. Almost. Story 5. Not an attorney, but I once served on a jury. The plaintiff was suing a cruise line. He claimed he'd contracted salmonella from eating eggs Benedict while on board. The infection turned him into a carrier, which meant the end of his career as a chef. It was a week-long case, and for most of it, his argument actually seemed solid. Then came Friday afternoon. His wife took the stand. She stepped up, took the oath, and before anyone could ask her a single question, literally as soon as she finished saying, "I do," she turned her head, glared at her husband with absolute venom in her eyes and yelled, "He didn't even eat the eggs, Benedict." "I did." There was a long, stunned pause in the courtroom. The attorney stood up quickly and said, "No questions, Your Honor." She was immediately excused from the stand. The case rested shortly afterward. I was the spare juror, so while the other jurors went off to deliberate, I stayed in the courtroom. To my surprise, the judge actually stepped down from the bench and came over to sit next to me. We whispered back and forth, quietly sharing our theories. "She probably found out he was cheating or something," the judge murmured. "Do you think she was telling the truth?" I asked. The judge just shrugged slightly, then said, "Doesn't matter. She nuked his case either way. He lost." And honestly, I had been convinced he was telling the truth, right up until the moment she opened her mouth. Story 6. I worked for a trial graphics firm and was assigned to a case involving a forklift driver who was driving recklessly and crashed into a cinder block wall of a new construction site. The impact caused enough damage that a man working on a ladder on the second level fell and fractured several vertebrae. The forklift driver had been reprimanded the day before for operating the forklift unsafely. In his deposition, he bragged about how many speeding tickets and traffic violations he had accumulated in his Corvette. Watching the deposition with the plaintiff's attorney was entertaining. Story 7. The client was on trial for murder. An OJ's case looked like a plot from Suits compared to this. No one has ever been worse at crime in the history of crime. We were appointed counsel, private attorneys who volunteer to step in when the public defenders run out. We were his fifth. He had fired the previous 4 because they kept telling him to prepare for a life sentence. They were right. My client was on trial for shooting his girlfriend twice. He did it because she had secretly terminated a pregnancy that might have been his. He found out when he picked her up from the clinic. As they drove home, they both texted a full hour-long conversation, including his threats to kill her when they got back, which he followed through on. His apartment building had recently upgraded to full-color, telescopic 4,000 resolution security cameras. We believe he didn't realize the blind spots had been eliminated. It looked like something shot for the Super Bowl. He was also the only 6'4" Hispanic man with bright red hair and a fondness for rare designer sneakers that either I or the victim had ever met. That made it difficult to argue it wasn't him, while the prosecution played his Gotham City highlight reel on a projector. He not only used his own gun, he also brought his phone with him to the remote area where it was later found. He texted a friend asking for the next one-way ticket to another country, no questions asked. He gave his friend his own credit card to buy it, because apparently you don't stick your homie with the bill. Finally, he had to hide his grin behind his hand while the victim's family cried on the stand. The jury deliberated for 43 minutes. Story 8. I am not a lawyer, but my mother-in-law's divorce attorney would probably have a perfect answer to this. My father-in-law began suffering from early-onset dementia, which set off a series of events that led to my mother-in-law, not wrongly, filing for divorce. Over the course of the 3 years it took to finalize the proceedings, his condition became unmistakably severe. He would sometimes show up to court wearing garbage bags, on the rare occasions his lawyer could even get him there. By the end of it, he was living in a memory care facility which was just as awful as you might imagine. His sister had power of attorney by then. When the divorce was settled, their estate was split 50-50. But my mother-in-law insisted he was faking it and hiding millions in offshore accounts. So she sued him. She couldn't prove he ever had millions to begin with. Multiple doctors attested to the legitimacy of his condition, but she was convinced it was all a scam. The entire lawsuit was a losing battle from the start. She had no case, no real evidence, and no expert who would back her up, but she kept pushing forward. At the time the divorce finalized, she had more than $750,000. By the time her failed lawsuit was over, she had about $125,000 left. Story 9. Not a lawyer, but this one always makes me chuckle. A friend of mine rear-ended another car. They exchanged information. There didn't seem to be any damage or injury, and they both went on their way. 2 years later, my friend gets a notice she's being sued for injuries related to the accident. The other party claimed a sprained wrist and was suing for $25,000 for pain, suffering, lost wages, and more. So, my friend calls her insurance company, and they assure her they'll handle it. To make a long story shorter, the insurance company first offers the claimant $5,000 to settle. She refuses. They bump it up to $7,500. She still refuses. They then offer $12,500. She laughs and says, "See you in court." About a year later, the case finally goes to trial. She wins and is awarded $2,300. 1/3 of that went straight to her lawyer. So instead of taking $12,500, of which she would have received 100%, she dragged it out for another year, went to trial, and walked away with about $1,500. Yeah, that's a win. Story 10. Not a lawyer, but I felt compelled to share my one and only brush with pure Soviet-tier absurdity. Canadian, by the way. I was in traffic court waiting for my turn when a guy was called up. He stood, and at first glance looked entirely respectable. Business suit, neatly groomed, clean-shaven, carrying a briefcase. I actually assumed he was a lawyer, until I realized he was sitting behind the bar with the rest of us. He stood and said, quite clearly, "Well, I have a driver's license with that name on it, but since it's in all capitals, you can see that's the name of a corporation, Your Honor." The justice on the bench did his best to remain calm and reasonable, but the guy immediately launched into a speech about systemic corruption and the need for radical reform, and this would become a recurring theme. The justice cut in, "That's not what we're here to discuss today. We're here for a speeding ticket. And if the defendant's name doesn't present himself in front of this bar, I am ruling a conviction in absence." So, the man hustled up past the bar, thus officially presenting himself for the case, and proceeded to deliver an indignant, borderline delusional set of arguments that felt like they were born of acid and paranoia. It was almost surreal. Some highlights. He tried to invoke papal law. The justice replied, "Papal law? This isn't Rome. That doesn't apply here." He then pivoted to admiralty law. The justice, completely baffled, asked, "Admiralty law? This is Alberta, the most landlocked province in the country. Where do you get admiralty law?" The man replied, dead serious, "Well, there used to be a fountain in the basement, sir." At this point, the man hadn't even entered a plea. The justice tried several times to steer things back on track, only for the man to respond repeatedly with some version of, "Well, I did it, but that's not the point." Eventually, a bailiff was called just to keep a watchful eye on whatever this was, and I, watching this unfold, finally realized I was in fact not dreaming. At last, the justice said, "Okay, fine, you've admitted you did it multiple times. I will accept that as a guilty plea." He handed out the fine and gave him 30 days to pay. Next case, Story 11. Okay, it wasn't my client, but I was prosecuting a case. Third offense DWI, reckless driving, negligent use of a firearm, which wasn't really relevant, though that law needs to be reformed right now. If you're drunk and a cop finds a firearm in your car, that's enough for a conviction. 99% of the time, though, our office dismisses that charge in exchange for a DWI plea and assault on a police officer. In our jurisdiction, a fourth DWI is a felony, so a preliminary hearing is required. Most defendants waive it, since it's usually obvious whether probable cause existed in a DWI case. But this defendant was pro se and refused to waive. So, I conducted my direct examination of the officer. Then it was the defendant's turn to cross. His first question, "Isn't it true you only added the assault charge because when I hit you, you started crying like a coward?" The entire courtroom froze, absolutely stunned. The judge sternly told him to watch his language and then recommended he get an attorney, since his question was also an admission. Pretty sure he was just in it for the spectacle. He immediately followed up with, "No further questions." The judge ruled that probable cause existed and moved the case forward. The defendant then came over to me, started talking plea deals, and we managed to wrap everything up before the end of the day. Story 12. Late to the party, but I am a lawyer, and I ended up on jury duty. Gotta love it when both sides burn through all their peremptory strikes before they get to you during voir dire. I sat on a criminal case. It was a late night or very early morning. Purse snatching. A man stole a woman's purse just as a police officer happened to be driving by. There was a clear line of sight on the suspect for all but about 30 seconds. On top of that, there was blood evidence from when he cut his hand jumping a fence, with lab results showing a match to a 99.9% certainty. The defense's entire argument, The man who stole the purse was wearing a shirt. Their client at the time of arrest was shirtless. Important detail: a shirt was recovered along the exact path the suspect had fled. Now, I understand, sometimes you have to work with whatever you've got to defend your client, and I respect that. That said, when the prosecution entered into evidence a statement from the defendant asking the arresting officer, "Can I have my shirt back?" you could feel the collective disbelief wash over the courtroom. So glad I practiced transactional law. Story 13. I am a public defender. Where do I even start? One case I had was actually solid for trial, but there were key facts that only my client could provide, so he had to testify. During cross-examination, he suddenly blurted out to the jury, an entirely rural white jury of conservative blue-collar paper mill workers. I thought I was going to get treated like George Floyd. Not exactly the best moment for that line. He completely misread the room. Another client got pulled over for driving at night without headlights. The officer gave him a warning and let him go. But as the officer was turning back to his squad car, he casually asked, "Oh, you don't have anything illegal in your car, right?" My client replied, "Nah, you can search if you want." Pro tip: if you give permission to search your car, they will search it. Big surprise. Open containers were found. His blood alcohol level was 0.27. I have so many more stories. Story 14. I've had quite a few cases doing Social Security disability. Usually it's people who went back to work without telling me, or who suddenly remember under oath that they volunteer 40 hours a week. But the most memorable was a guy being questioned by the judge about his marijuana use, which was noted in his records. Then, when asked if he used any other drugs, he started listing pretty much every drug you can name. He even told us all that his last use was about a month before the hearing. That was a denial I didn't appeal. I still remember the interesting call with his mom afterward. She was really upset about the denial, and I recommended not appealing. The judge had actually done him a favor by completely leaving out all the hardcore drug use in the official decision, so if he got clean and tried again in the future, that wouldn't count against him. But his mom thought the judge had clearly denied him based on nothing but alcohol and drug use, which made the situation even more complicated. Story 15. Not a lawyer, but I was involved in a 5-mile-per-hour car accident. It was bumper-to-bumper traffic during rush hour, with everyone inching forward about every 39 seconds. The genius next to me swerved into my lane, and his passenger side rear tire grazed my driver's side front tire. We pulled into a fast food parking lot to wait for the police because he insisted on filing a police report. 1 week later, I got the news. He claimed I pulled into his lane, and he had a long list of injuries. I was absolutely livid. He was lying and trying to game the system. So I went on a mission to learn everything I could about him and discovered he fancied himself a personal trainer. Amazingly, he was holding a group session at a public park the very next weekend. Now, I live in Florida, where recording without consent is generally illegal unless you're in a public place. So I set up on a park bench that weekend and recorded him for an hour and a half. Pull-ups, push-ups, rope climbs, throwing a giant medicine ball. This dude was definitely in shape. I sent the video to my insurance company and told them not to pay a dime. They told him to pound sand, and we all lived happily ever after. Story 16. When I clerked for a trial judge, we had a divorce case where the wife was asking for far more than the standard calculation for maintenance or alimony would allow. On her trial day, she showed up dressed head to toe in designer clothing, carrying a high-end designer purse. She lost. Afterward, the judge told me, if she wanted to claim she was so bad off financially, she should have left the pearls and Prada at home. Story 17. Flip side of this. My ex was a barrister, and while still studying to pass the bar, she took part in a courtroom-style exercise. The class ran a mock trial using real court cases, including victims' and perpetrators' testimony, as a training tool to argue how they would have gotten someone off or prosecuted them. She was just watching, surrounded by lots of very posh, highly educated and wealthy people, all aspiring lawyers and barristers nearing the end of their training. Some would literally be working in courts on their pupillage within months. During the mock trial, one of the women playing the prosecutor made a dismissive comment. "Well, they have to be lying. Nobody can possibly survive on only £20,000 a year. They must have undeclared criminal income elsewhere." At that time, the average wage in the UK was about £22,000 a year. My ex raised her hand and said, "I earn less than £20,000 a year, and I am literally paying my own way through law school." Several other students nodded in agreement. The woman prosecuting was so out of touch with reality that she couldn't fathom that anyone could live on slightly less than the average UK wage. To her, it was an immediate conclusion that the declared income was false and therefore criminal. Fun fact, prosecution barristers earn almost nothing, especially during training, since they're paid by the state to put away criminals. The rich barristers all work in defense, where criminals pay extortionate sums to avoid jail. My ex was training for prosecution. The woman was training for defense. Story 18. This is rather boring compared to other stories. It was a child custody case in a county where I don't normally practice. My client, the mother, wouldn't agree to a pretty good settlement offer. She insisted on having the judge decide, wanting her way 100% rather than settling where both parties walk away with some wins and some losses. The hearing began, and as usual, we all stood when the judge entered. Then the judge unleashed a tirade, telling us to sit down. He said it was obvious we were from the big city, all dressed up, but this was his courtroom and he was in charge. He then mentioned his military service, and I knew right then we weren't going to win. The father was a former military man. I pissed the judge off by not taking the time to learn how he runs his courtroom before showing up. The judge issued a favorable ruling for the father. Mom was furious. I walked away with two key lessons. First, settlements are better because you maintain some control over the outcome. And second, always get to know the court before you appear in it. Story 19. My attorney who helped me through my divorce once said the first thing she was taught in law school was, know your judge, know your judge, know your judge. As a lay observer through several motions and hearings, it became very clear that each judge had their own particular way of receiving information and making decisions. I didn't find anyone especially partial except for one looking at you, Judge McManus from Nevada County. She was afflicted with a traumatic brain injury. She allowed an ex-parte communication in my case that favored me, even though opposing counsel was not present, and I objected. Speaking of not winning, I remember a case in Department 5 where financial matters were decided. A man had requested to bifurcate his case, and the judge agreed on the condition that he maintain health care coverage for his soon-to-be ex-spouse. Guess what? He didn't. Guess what happened next? She suffered a significant accident and racked up medical bills totaling tens of thousands of dollars. A motion was filed to compel him to pay those bills. What followed next shocked me and stunned the entire courtroom into silence. Of course, this foolish man complained loudly, insisting it wasn't fair for him to pay these medical bills. The judge, normally stern but fair and calm, lost patience. She bellowed. I granted you this verification as you asked, and you did not comply with my order. You are completely financially responsible for her medical bills, and you will obtain health insurance for her immediately. Any further questioning of my order will lead to sanctions and possible contempt. Am I clear, Mr. Do Not Understand Court Orders? Mr. Do Not Understand Court Orders grumbled but replied, "Yes, Your Honor." It was the first time I saw a gavel drop without the hammer actually falling. You could have heard a pin drop. Story 20. Going to trial is expensive. Both sides had to split the cost of the court stenographer, $1,400 total, so $700 each. During the lead-up to the trial, I told him multiple times, "We are not the IRS. Yet the guy literally paid $700 just to ask me under oath if I worked for the IRS, because apparently my repeated statements and all our correspondence on my state's letterhead weren't convincing enough. The amount in dispute was about $3,000, so $700 was a hefty sum for the taxpayer. Story 21. I am not a lawyer, but I had a law class taught by a lawyer who shared this story and had us do a project on an active case he was involved in. Not civil, he wasn't breaking any laws by doing this. Basically, this guy wanted to see his kid on his birthday. He went over to his wife's house. They were living separately. The kid said he wanted to go with his dad, but the mom refused. The guy forcibly grabbed the kid and tried to leave. The wife attacked him, and he ended up grabbing a hammer and hitting her a couple of times. When it came time for court, the guy decided to represent himself because he claimed he had done it before and won. At his pre-trial hearing, not even the trial yet, he tried to get out of the case by arguing that his name wasn't actually the one on the judge's sheet because he writes his name in all capital letters, which, according to him, makes it an LLC. The judge wasn't buying it, but the guy kept insisting he didn't recognize the charges against him personally, that his LLC was being sued, not him as an individual. The judge revoked his right to self-representation, saying he wasn't competent because he refused to acknowledge that he was being charged personally. So, he was assigned a lawyer. He lost the case and got really upset, insisting he could have won if he defended himself. He appealed, claiming the judge violated his civil rights by taking away his right to self-representation. But he conveniently didn't send the transcript of the competency hearing that justified the judge's decision. Again, on appeal, he was assigned a lawyer who happened to be my teacher and was not allowed to represent himself. Then, in a bizarre twist, he tried to sue my teacher because he didn't want a lawyer that badly. My teacher got unassigned from the case after telling the judge all this, but the guy didn't win the appeal. Story 22. My squad was executing a search warrant on a stash house as part of a coordinated takedown of a violent organization. Multiple houses were being searched simultaneously. The house I was in was a known stash for guns and drugs, and during our investigation, one of our undercover agents had purchased several guns traced back to this location. I was searching the kitchen in full tactical gear when someone opened the back door and poked their head in. We locked eyes for a moment, then he quickly backed out and slammed the door shut. I ran to the door, opened it, and there he was, standing with his hands up. I sat him down on the patio steps to start gathering his information, while my sergeant ran a check through NCIC. The guy was cooperative but wide-eyed and visibly nervous. As I stood in front of him, I noticed a clear outline of a gun in his jacket pocket. My body-worn camera footage showed textbook printing of the firearm. He didn't resist. He calmly accepted being handcuffed and arrested for possession of a handgun by a prohibited person. After booking, he made a phone call from jail. The system clearly states all calls are monitored and recorded. During the call, he told the other party he had a satchel with $700 in cash and cocaine that he tossed over the fence before I came out the back door. A couple of detectives searched the area. Despite a heavy snowfall that morning with no footprints near the bag, they found it untouched and uncovered by snow. Inside was $700 in cash, cocaine, and the guy's driver's license. He filed a motion to suppress, arguing I had no right to detain him. He lost that motion decisively and pleaded guilty. Our state's attorney cited roughly 7 well-established cases showing his argument was comically wrong. At the hearing's conclusion, the judge told him he was going to be placed in an employment education program because he clearly needed to find a new job, given how terrible he was at being a drug dealer. Story 23. Not a lawyer, but when my ex-sister-in-law and brother were getting divorced, my niece filmed her mother, my ex-sister-in-law, throwing bowling pin-sized rocks at my brother's truck. My ex-sister-in-law was in an unmedicated bipolar manic phase because she insisted she didn't have a problem and was obsessively working out at the gym, which meant she could throw those rocks with a lot of force. She screamed at my niece to stop filming, citing privacy concerns. Later, my ex-sister-in-law was charged with domestic violence and pled not guilty, claiming she didn't do anything wrong. She was so convinced of her innocence that she didn't tell her lawyer about the video. The lawyer was in for a nasty surprise when the footage was played in court. In a nutshell, she was charged and ended up on probation. Story 24. Not a lawyer, but my ex-wife dragged out custody hearings for several years, all in an effort to keep me paying for her lifestyle. Her main tactic was character assassination. After several years, though, it wasn't working well because all the officials involved could plainly see I was nothing like the person she described. Once it became clear that they didn't believe her claims that I was abusive, violent, negligent, or a likely PDF file based on the evidence from years of hearings, she switched tactics to portray me as financially unreliable. Keep in mind, I was enlisted in the Air Force at the time. She told the judge she expected me to be discharged soon because of a list of accusations, all of which were debunked. The judge asked me if that was true. I answered honestly. The only time discharge was even suggested was when we were still married, and she was calling my first sergeant and commander daily trying to get me fired. Once we divorced and they no longer had to field her calls, the topic never came up again. In fact, I was the highest-ranking, second most awarded, and most knowledgeable person in the unit. The judge asked my ex-wife if what I said was true. She admitted it was, that she had actively tried to get me discharged. In my head, I was screaming that she tried to get me fired to justify cutting me out of our daughter's life entirely. But when I glanced at my lawyer, I saw he was suddenly very interested in what was happening, so I stayed quiet. The judge asked her again, very carefully, "You admit that you actively tried to get the sole source of income for you and your daughter fired from the very job that provides that income?" She said yes. The judge asked why. She replied, "Because I don't think he's a good fit for that job." My lawyer put down his notes and smiled. Story 25. My buddy served as a public defender in Michigan for a few years. Every couple of months he'd get the same guy for different charges. None serious enough to keep him in jail because others were doing much worse. Charges included public intoxication, also known as walking while drunk; failure to pay spousal support, also known as I lost my job but still took the kids on my weekends; possession of marijuana before it was legal, also known as a roach in an ashtray on his porch. Usually, the case would end with community service or be dismissed with credit for time served. After about 6 cases, my buddy finally asked his client why he kept having such bad luck. "It's in my blood," the client replied. My buddy didn't get it. "Read my name," the client said. "Clarence Deadman," my buddy guessed. Clarence Deadman. I'm pretty sure I got the spelling wrong, but my buddy, being of Scandinavian and German descent, always misread and mispronounced the name. No one ever corrected him until the client said it aloud. After that, my buddy switched to corporate law. Story 26. I was involved in a lawsuit, not as a lawyer, but as a party. The other guy kept trying to explain the law to the judge in a way that would make him look right, even though it wasn't true. The judge had to repeatedly tell him otherwise. I had to tell him multiple times to stop bringing up points that were completely unrelated to the case. The best part came a week later, when we received a letter in the mail, a carbon copy of a letter he'd sent to the judge the day after the trial. In it, he insisted the judge was completely wrong and that he was actually the one in the right. The judge's response was simple. The letter wasn't submitted by the court date and would not be considered. The judge also warned him that if he did it again, he would face penalties. Story 27. Not a lawyer, but after 17 years and 8 family court cases, I might as well have gone to law school. In my last case, my ex once again wasn't paying his measly child support and was finally facing jail time. This was only because he and his lawyer had brokered a hallway deal last time that included a suspended 6-month sentence. So, unlike most of our other cases, no hallway deals this time. I was called to stand. Exet's lawyer asked, "Did you or did you not leave your son unsupervised from 5 p.m. to 10 p.m. on such and such dates?" I answered, "I did." The lawyer pressed, and what precisely was so important that you couldn't be supervising your son? I said, I drove to a data center to install hardware for work. The lawyer asked, and do you think this was appropriate? I replied, yes. Then the lawyer asked, with a smug look, and just how old was your son? I said, 19? My ex-doll lawyer turned a color I'd never seen before and abruptly stopped questioning me. The kicker? It would have been his weekend normally. Obviously, the 19-year-old wasn't subject to this anymore, and my younger child was with his dad. My older son had a shift from 4 p.m. to midnight that Saturday, so he was at work when I left and still working when I got home. I am really not sure what my ex told his lawyer, but this moment perfectly summed up 17 years of wild court drama, including the time his response to non-payment was to accuse me of child neglect simply because I worked full-time, and child abuse because I made our then 12-year-old take out the trash once a week. Story 28. It was a civil case. Back when I worked for a housing association, we basically owned a small cul-de-sac, and nearly every resident had lodged complaints about one particular tenant. Unfortunately, the tenant didn't have the highest character and seemed to have a few questionable friends in the area. We also suspected they were involved in drug dealing, but that case was still being built, so we couldn't bring it up in court. Our star witness was a former doctor who had just moved in. It was one of the few available bungalows we had at the time. Even they, with no prior knowledge or bias, had made a formal complaint about the tenant. Unfortunately, they were undergoing chemotherapy treatment when the case went to court, so we had almost nothing to present in terms of direct testimony. Our lawyer looked as green as grass. Their advice? We shall say we're still expecting the star witness to arrive. They had a medical appointment they couldn't move. Just act confidently and keep a poker face. So we went in. Their lawyer also looked fresh out of law school. Our lawyer gave our side, calmly explaining the situation while noting that our witness had not yet arrived due to a prior commitment. Then their lawyer stood up and launched into a long-winded explanation about all the protections his client had under housing law and what our obligations as a housing association were. The judge cut him off cold. Don't be lecturing me on what the law is. I've done this far longer than you have. The other lawyer sheepishly sat down. We continued discussing the situation briefly. Then their lawyer stood again and said something like, if their witness doesn't appear soon, they must proceed without them. The judge didn't let him finish. Yes, I am aware of how things work in a court. Be seated now and wait, or make your plea now. That time, the tone was much harsher. The opposing lawyer completely lost his bottle and asked to end the case. The tenant would accept responsibility, and an agreement would be worked out with the housing association. In the end, it wasn't the client who lost the case. It was the lawyer who just couldn't stop talking and ended up losing the judge's and his own client's confidence. Story 29. I do at work for law enforcement in a small city. One day, police were called to an old folks' home because some elderly man who didn't even live there was harassing people during bingo. Officers show up, ask him to leave, and he gets belligerent and attacks one of them. He's quickly and cleanly subdued. Textbook takedown. No injuries, no charges. Everyone involved, the officers and the residents, just wanted him gone. But then it got funny. We had this local politician who's a well-known attention seeker, and they must have been thrilled to finally have a pet injustice to rally behind. Unfortunately for them, they backed the wrong horse. Footage from the facility gets requested. I am the one who obscures civilian faces, so I got involved, and soon a local news segment airs. The video is heavily edited. It flashes from the officers first approaching the man to the takedown, conveniently cutting out the entire sequence where he attacks the officer. It makes it look like the cop just slammed some helpless old guy for no reason. They even interviewed the man. His big quote? The officer got lucky. If I hadn't been surprised, I would have kicked his buns. Yes, buns. That was apparently the best soundbite they could get from him. So now, emboldened by the media attention and probably assuming the edited footage is the only evidence, he decides to press charges. Except the unedited footage exists. In it, you can clearly see him go after the officer. You can also see the horrified faces of the elderly residents watching, all of whom were happy to testify. And if that wasn't enough, the body cam footage shows the officer enduring multiple swings while trying to de-escalate and only taking him down when the man grabbed for the officer's firearm. That's where my involvement ended, but I can't imagine things turned out well for him. Story 30. Anyone who believes the world is out to get them. Vague, right? But you know the type. It ranges from genuine delusional paranoia to the far more common flavor. Everyone else is to blame for my problems, and I take zero responsibility. These are the worst clients. Full stop. They don't listen to advice. They drain your time and energy. They argue with you about the law you studied, and they likely leave a 1-star review because you had the audacity to say, "No, that's not how the law works." The irony? Some of them do end up winning in the sense that they get a result they wanted, but it's almost always less than what they could have achieved if they had just listened to the attorney they were paying. I used to do a lot of consultations. The moment someone launched into a 20-plus minute rant about how everyone in the universe was conspiring against them, it was an instant no from me. Story 31. Not a lawyer, but I was tangentially involved in a case where someone tried to pull disability fraud after a work-related traffic accident. He claimed a specific type of back injury. I don't remember the exact medical term, but he insisted it caused so much pain that he could barely walk. Problem was that didn't line up with the social media posts. There were photos of him on a ski trip after the alleged injury and video of him dancing enthusiastically at a friend's wedding. His lawyer tried to spin it by saying he has good days and bad days, but sure, okay. Fast forward to court. He's sitting at the defense table making a huge show of being in pain, hunched over, grimacing, one hand constantly on his lower back like he's auditioning for a medical drama. Then our company's star witness takes the stand, an occupational therapist who specializes in back injuries. The lawyer spent about 30 minutes establishing the doctor's credentials, degrees, publications, years of experience, the whole deal. Then, finally, he gets to the fun part. "Are you familiar with the injury the worker claimed he had?" the lawyer asked. "Yes, extensively," the doctor replied calmly. "Does it have any notable characteristics?" the lawyer continued. The doctor nodded. "Several," he said. "One of the most obvious is that patients with this injury experience significant pain anytime their back is curled or bent. For instance, hunching over like this," he hunched his back, perfectly mimicking the guy at the table, "would cause excruciating pain. Most people with this condition prefer to stand rather than sit, and if they must sit, they usually stretch out their legs and lean back to keep their spine as straight as possible." Which, of course, was the exact opposite of how this guy had been sitting the entire trial. The moment the doctor started describing the posture, the claimant's eyes shot up and his face instantly read, "Oh crap." He did not win the case. Story 32. I have a relative who did some time as a public defender. My 2 favorite losses she told me about. The Japanese man who believed he was being pursued by snow monkeys. She managed to plead him out on the condition that he get psychiatric help. Then there was the one who, right in the middle of trial, calmly stood up, walked over to the corner, and relieved himself behind the courtroom door. She told me, yeah, the case was pretty much lost at that point. I don't remember what either person was charged with, though in the second case I'd guess something alcohol-related. Those stories were funny. The ones from my paramedic relative, much less so. Unless you're into very dark humor, like paramedic-level dark humor. As for me, I've had a couple courtroom moments too. I once went to court over a trumped-up speeding ticket. I actually won that one. The state patrol officer testified that he had clocked me using his tracker system, which, as I later found out, doesn't even exist. He said it disables his entire dashboard when activated, so he had no idea how fast he was going either. I couldn't believe it. I remember thinking, did you just say you disabled your entire dash and still wrote a ticket? Years later, I wasn't so lucky. Lost a case on another made-up charge. The same state patrol testified that he had no way to estimate my speed, so he made one up. Let me set the scene. He was in an unmarked SUV, riding my bumper and threatening to crush my car. I panicked. So yeah, I hit the gas, like people running for their lives do. Still, I got nailed for it. The whole court setup was shady. The judges were part of this friends driving schools scam. At the first hearing, they offered a deal. Pay $75, attend traffic school, and your ticket gets reduced. The room was packed, and I was the only one who didn't take the deal. At the second hearing, I already knew it was going bad. After the state patrol admitted under oath that he had made up the speed, the judge turned to me, scowled, and said, "Is there any reason I should listen to what you say?" Story 33. I had a client whose family came to me asking for help to get his brother bail pending a drug trafficking charge. What I soon discovered was that the entire family was actually the largest drug trafficking syndicate, controlling the influx of a significant amount of drugs coming into the state on an industrial scale. They were all foreign nationals, loaded with cash, connections, and power. I told them plainly, there is no way a court will grant bail. He's a flight risk. He has the money to disappear, and he's part of an extremely violent drug trafficking syndicate. But they insisted, offering me tens of thousands of dollars in cash to at least try. I rejected their offer. A few days later, the threats started coming in, pictures of my wife and kids, messages warning me to comply. It's par for the course with these types of people. I've had threats before. You get used to it. It's just a tactic to intimidate and bend you to their will. As far as I was concerned, they could get crapped. I don't care, and I won't be intimidated. There's more to this story, but I will leave it there for now. Story 34. I am not a lawyer, but one night I seriously violated my parole. Well, I did a lot of times, but this night in particular was rough. I went to the bar and chatted up this girl. We ended up back at her place. Honestly, she was annoying. I don't remember much from the night, mostly that I was drunk, but something inside me snapped. I used my gun to shut her up. Obviously, they caught me. I was screwed. My lawyer knew it too. So I decided to do what they do in the movies. Plead crazy. In court, I went on and on about how she was a devil and how I ended her life for that. I kept insisting she wasn't human. I tried to rack up all the crazy points I could. I even told them exactly where I left her body and how I killed it like they kill zombies. Then in the middle of the court session, no joke, some CSI guys interrupted and spoke privately with the judge about missing evidence. But I overheard them. It was her body. I put 3 bullets into her and her body was missing? I begged, please incarcerate me. I am serious. In the end, I pleaded guilty to everything they threw at me: public intoxication, parole violation. Hell, I even took public urination, even though I think they made that one up. My lawyer was pissed, but I was like, if she really is a devil, I want to be safe behind bars, you know? Story 35. The client was on public transportation when his mirror was struck and broken by another vehicle, though the damage was claimed to be more serious. I spoke with him, and he sounded completely credible. He then attended an examination under oath, which the insurance company conducts before we consider filing suit. He described the incident very well, and I could usually tell if someone was lying based on their answers and tone. He showed no signs of deception. After the examination, defense counsel showed me video footage from the bus. I face-palmed, dropped him as a client within a day, and referred him elsewhere. Later, I checked court records and discovered this was not his first attempt at such a claim. Story 36. A client came to me with this situation. He began a relationship with a pregnant woman who had nowhere to live, so he let her move into his house on the condition that the baby would take his last name once born, since the biological father was absent. 5 years later, they separated, and now he wants to file a request to change the child's last name. The problem, in my country, identity fraud is a serious crime. If the authorities find out about this, he could face many years in prison. Essentially, he was confessing to a crime. Story 37. Not a lawyer, but my ex and I had a virtual hearing about our divorce. He was completely irrational, and when it was his turn to testify, he immediately started lying, even claiming our kids' therapist shared details from their sessions. My lawyer objected and said if the therapist had something to say, they should be present in the hearing. During cross-examination, my lawyer tore him apart. I heard whispering throughout the hearing, and finally the judge asked, "Who's whispering?" The court reporter said it was coming from his side. I said, "He's got his girlfriend telling him what to say." He denied it, but then visibly told her to leave his office. The judge admonished both him and his attorney for the nonsense. The court ruled in my favor and made him pay part of my legal fees. Not sure if he fired his lawyer or vice versa, but suddenly he had new counsel. I also requested that all future hearings be held in person because of this. Thank you for watching. If you enjoyed this video, be sure to give it a thumbs up, subscribe, and hit the bell icon so you never miss an update.